That's the point. There's no material difference. Yes, yes, my lord. So
can you resume your seat? Kindly resume your seat.
Which actually deals a blow to the application.
Kindly resume your seat. By quote, our considered view is that the alleged preliminary objection is unnecessary and does not seek to assist any process before this court. Every party has an inherent right to present the appropriate formulation of their reliefs or other process before the court to enable the court to determine the real matters in controversy. The objection is dismissed.
As the court pleases, Fali.
You've taken our time and energy for nothing. So, Mr. Abedu, move your application.
Lady, I'm grateful. Lady, respectfully, before you is an application on notice for leave to amend the reliefs on the motion paper for an order of interlocutory injunction filed on the 7th of March 2024. My lords, I move in terms of the motion paper and the supporting affidavit as well as the measure. Lady, there was a patent omission on the motion paper in respect of our application for interlocutory injunction, and milady, we have stated the right formulation.
So which is this, what is this omission?
Milady, the omission was that.
What's different here from what's the original?
Yes.
You've attached the proposed amended motion.
Yes, we have.
Yes.
Lady, there were patent omissions.
Please, yes, point it out.
Yes, and milady, this is where in our motion paper we have stated the actual thing, that an order for interlocutory injunction to restrain the speaker and the clerk of Parliament of Ghana from... Yes,
I think my lady is asking you to point out the omission in your original
very well
process. That is what she's asking you to.
Very well. Lord, I'm grateful. Lady, at paragraph 3 of our motion paper,
I think that the only difficulty is what Mr. Story has described as muddle. The words for his assent from
Exactly.
presenting to the president, for his assent from the attorney general, from assenting.
Exactly.
Is that not it?
It does.
That's what you are seeking to delete.
Exactly.
So, I mean, what's so grave is my question.
Lady, precisely the point.
You want to present a more elegant
Exactly.
formulation that does
Exactly.
not
Exactly.
have any muddled words.
Exactly. Milady,
Yes.
very well. Milady,
Are you done?
Milady, this has been stated in our proposed.
Please hurry up. We have a very full day.
Very well. Milady, all said and done, I move accordingly.
Thank you. Mr. Sorry.
The ruling of the court in the preliminary objection actually dealt with this part. Because my lady said that
You could just have waited.
a party is
It's
entitled
okay.
to
You
comment.
have nothing to say.
Very well, my lady. And I thank the court.
Mr. Sorry has nothing
I
to
say I
say.
thank the court for using my words to point out what he should have done.
Yes, Attorney General.
Lady, I'm not opposed to the application. I think it just needs to correct a tautologous formulation, or just some tautology in there. That's all.
What did you say?
My lady, I think my lady friend actually sought to correct a tautologous formulation. So if my lady...
I didn't know this rendition.
Yes.
Tautologos.
Yes, because really, my lady, if you look at it, it says, an order of interlocutory injunction seeking to restrain the speaker from presenting to the president for his assent to the attorney general from assenting to the human.
So that's where the tautology
yes,
is.
Precisely. That's
Which is tautologos.
Precisely.
Yes, definitely clear. Are there any, so by court, the applicant is granted leave to amend his application within the terms as sprayed by close of day on Thursday, 9th of May 2024. Are there any other fundamental matters that we should deal with?
Lady, our second application is not before. Lady, our second application respectfully is not before the court, so we don't know whether we can speak to same.
You have another application?
Yes.
What is that?
Lady, that's what I pointed out earlier on.
Please speak into the microphone.
Lady, that's what I pointed out.
Are you not ready? If you're not ready, don't come to court.
Lady, we have that motion on notice for leave to file supplementary affidavit in support for application for.
And why is it not before the court? Because you filed it yesterday.
No, we filed it on the 8th of March.
So why is it not before us?
Lady, we are equally surprised.
I beg your pardon.
We are equally surprised that it's not in your document.
Do you have it? Okay. You have it. My colleagues have it, so let's go on. Move it.
Very well.
Please move it.
My lady, I thought that since he has admitted that it was belatedly filed. When?
Filed it on the 8th of March. I hadn't seen it on my. Can you allow me to manage my vote? Mr. Sorry.
I apologize, my lady.
Lady, we have before you.
Mr. Bedun,
Yes, my lady.
because of the nature of your amendment, which doesn't really go to the root of anything, of your reliefs. It's just a better formulation of it. I think you should move your application to file the supplementary affidavit, so that we can get it out of the way as well. Why is there a need for you to file the supplementary affidavit?
Lady, we have deposed at paragraph 6, 5 and 6, actually, of affidavit in support that there was an inadvertent omission on our part.
Mr. Bedru, what is this business of referring to things without saying what exactly you were? What's salient facts?
Lady, we're saying that in our...
How can I exercise my discretion when I don't know what you want to do?
Lady, we indicated so in our proposed attached to the application, and particularly paragraphs 4, 5, 6, 7, 8, 9, and 10.
Four says that
That's 4 to 10.
4 says that the bill prescribes custodial sentence as punishment for any violation. You need to put that into your statement of case. That's what you're saying.
Exactly.
5 says that nowhere have these persons indicated they are acting for and on behalf of the president. Who are these persons?
We are referring to the private members who introduced this bill.
But it's inappropriate to refer to the private members in these words. These persons. It's inappropriate. I can't give you leave to put this in an affidavit.
Lady, I'm grateful for the cue.
And then you say, therefore, for members of parliament who are not cabinet ministers to place this bill before parliament, it is constitutionally flawed. What does that mean? Could you ensure that if I give you leave, you articulate it so your friends are ready?
Very well.
Then the next paragraph is which one?
Next, 6, 7.
6 and 7?
Yes.
I must say that I have a difficulty with your language and the language of the affidavit of Mr. Sorry. I mean, I was going to come to that. I mean, some of the language is intemperate. We were going to deal with it. Mr. Sorry, you can sit down. Some of the language in your affidavit is intemperate. So please employ more courteous language. In the same way as I'm going to tell Mr. Abedu to watch his expressions. Just say yes. Thank you.
Yes, Malini. It's the temperature.
Mr. Abedu, you can come back. Mr. Abedu, you might come back on your feet.
Lady, we are equally referring to paragraphs 7, 8, 9, and 10.
7.
Paragraph,
You see, please avoid the presentation of essays. Be specific. What do you mean by indeed grave? Grave is not a principle of law. It's not a precept. It's not a doctrine. And therefore, your articulation should direct the advocacy. So, as much as we'll give you leave, it cannot be in the words you have presented to us. And verse 8, look at me. Paragraph 8. Yes.
Lady, do I read with respect?
Paragraph 8.
Yes.
You said that the instant action is premature. Is that what you're saying? Mr. Sky, Mr. Abedu?
Yes, milady.
You say that any argument that the instant action is premature has no basis, simply because the bill has been passed by Parliament and is awaiting presidential assent. There's no better time than now for the plaintiff. Please upgrade all your expressions into legal, because this affidavit, whose affidavit is it? It's an affidavit of Mr. Sky, who is a lawyer. All right?
That is so.
Thank you. I'll listen to you, please. So Mr. Abedu moves his application for leave to file supplementary affidavit.
Exactly so, my lady. Exactly so, my lady.
All right. Attorney General, I think I should listen to Mr. Sorry before I listen to you. Mr. Sorry.
My lady, we will not oppose it. I was going to make a proposal subject to the convenience of the court that if you look at the nature of the amendments that are sought by an learned friend, in one breath, he has leave to file just an amendment to his motion paper. So we are going to get an amended motion paper, a supplementary affidavit. If he just filed a fresh motion so that we just respond to it once and for all, maybe it will be more convenient. Because referencing, I got to realize this morning that when you have too much of it on your desk, it can create problems. If you would just file a fresh one, put his supplementary and all of that into it, we'll respond to it and we'll be here. That was the proposal I wanted to make. So consider it to be tidier and neater for everybody.
Thank you. Yes, Attorney General.
I was actually going to oppose this application. It offends every rule regarding affidavit. It is argumentative, it's offensive, it doesn't contain any facts at all. The rules governing affidavit are that you depose to only facts and not law. Essentially, the argument here, arguments of law. And I think it's very much offensive to the rules governing affidavit. Secondly, as my lady pointed out earlier on, the language is intemperate, and for that matter, it again offends the rule regarding the avoidance of scandalous averment or the positions in an affidavit. But I think that the affidavit, with all respect, is unnecessary because the essence of his case has been made out in the original affidavit filed. This affidavit only seeks to add on to it through matters which essentially are matters of law and also are scandalous, ought not be permitted. I am really, with all respect, a stickler for rules. That is why my affidavit, if it's not of fact, I do not really depose matters. They must be matters of fact. If they are not facts and they are matters of law, they ought not be countenanced in an affidavit. Secondly, they are also scandalous and they are irrelevant. I think if it's going to...
Give me a minute. Eh?
Right.
So the averments proposed in the sought for supplementary affidavit do not speak to facts.
Respectfully, that is so.
The language is intemperate. That I will not note down. Go on.
Right. And respectfully, I am supported by Order 2008 of CI 47. Indeed, CI 16 has no provisions on affidavits. The only provision on the content of affidavits is contained in Order 2008 of CI 47. And it stipulates that an affidavit shall contain only facts that the deponent can prove. Respectfully, there's no room for matters of law. And I think that, indeed, this affidavit, to the extent that it doesn't bring any new fact, doesn't state any fact at all, ought not to be allowed. Secondly, Rule 9 of Order 20, CI 47, again, says the court may order any matter which is scandalous, offensive, irrelevant, or otherwise oppressive to be struck out of an affidavit. Respectfully, all the matters here are very much scandalous. In terms of the use
You've already said so.
Precisely. And I think that appreciate. Indeed, my friend has the opportunity of filing an affidavit together with the motion that the court, I'm sure, has already granted leave for him to amend. And he can state it. But of course, it must be cautioned that there cannot be the insertion of any scandalous or argument of law. I pray I put it.
Oh, yes.
That's why I want the news to reflect that when we are not around and anybody wants to touch something.
My lady, very small point.
I will notice you very soon.
I'm most grateful.
Mr. Sorry, should I listen to you? You'll be speaking out of 10. You've already had your opportunity.
My lady will realize that because of the difficult position in which the Attorney General has put me on one occasion.
He's pushed you?
Yeah, he's put me because if on a point he aligns with the plaintiff, it will usually be better for me if the two of them will take
I beg your pardon. Nobody needs to align with anybody.
No, there are times when he took a position against me.
Mr. Sorry, I beg your pardon. I beg your pardon.
Very well. Let me move on. Let me move on from that.
If you have nothing to say.
No, I have something to say against the submission. Which is that, based on the practice that we all took you from in terms of the court's direction, the Attorney General filed no process indicating his objection to what is scandalous, what is matters of law this morning, in order to enable us all prepared to come and take this point.
I beg your pardon.
The second point.
I will not note you down. Thank you.
There's a second point. The second point is that, apart from saying they are scandalous and all, which are the words that are scandalous, which ones plead matters of law? So if my lady would, or if the court would exercise its
Can I manage my court?
Oh, I was just making a submission.
Can I manage my court?
Very well, my lady.
Thank you.
Well, I was just making submissions to assist the court.
Order in court, please. Order.
By court, after listening to all counsel, the court agrees with the suggestion of counsel for first defendant and orders the plaintiff applicant to file a fresh motion paper with supporting affidavit and statement of case. Plaintiff is also given leave to address any matters of fact and issues of law in the new process. Plaintiff applicant is given up to 17th of May. So now you have moved from 9th to 17th of May. Up to 17th of May 2024 to further new processes. Counsel for defendants are given 7 days after service on them to file any processes that they may wish to. But
just to point out that he should address new matters of fact in the affidavit, but not issues of law. Especially that would be offensive on the rules. Affidavit contains matters of fact, new matters of fact.
And I said so.
No, it said new issues and issues of law. I heard.
Yes.
No.
I said matters of fact.
Yes.
And issues of law.
No,
that they want to.
Right. Because
I don't want any further applications.
No, right? Because issues of law cannot be an affidavit. So
no. Listen.
Right.
Listen. I don't know if you listened to my ruling.
Yes.
I said the plaintiff applicant is to file a fresh motion paper with supporting affidavit and statement of case.
Oh, statement of case.
Yes.
That's fine.
That's part of the ruling.
That's fine.
If you missed that.
That's fine. Yes.
This is why I said
yes.
he may introduce any new issues of law, because right. I'm not going to give you any new, I'm not going to listen to any further applications right. for amendment. So just do a good job. And everybody say what you want to say. But I think it's necessary to say this. Mr. Sorry, the material affidavit is separate. Especially the affidavit of Mary Wendy Yeboah, which you have now withdrawn. Do well not to introduce such material.
I'm most grateful, my lady. Sometimes you respond to what comes from the other side. And that's the reason. But I'm taking cue. When they take a shot at you, you throw something back.
Attorney General, kindly resume your seat. There's something I want to say to you too. I think you didn't file any process in this one.
Indeed, I filed an affidavit in answer to the application for interlocutory injunction. It was filed on 25th March 2024.
Thank you. Please give me a minute, sir. Attorney General. Please remain on your feet. Yes. Did you want to say something? Attorney General, look at your original paragraph 8 of the affidavit in answer by Nana Kunedu Frimpong. You state the issues 3 issues. What's your position in relation to them? So this court is directing you to state what your position
in a similar case.
In the statement of case.
Hey, that's right.
And so that you don't surprise anyone.
Wait, that's right. But that's because, as I said, I stick to the rules.
Yes, but the rules require you to file a statement of case. But now the court has
already a similar case. I'll file similar
case. Are you going to file a statement of case?
You have ordered out.
If you will file, yes. If you don't file a statement of case, I will not let you
be heard. Yes.
Argue any points of law.
Yes. Yes.
I will not hear you.
Yes. But the court has now ruled a file similar case, so I'll file. Otherwise, I only have said the law in an affidavit. No.
You were required to do so in the statement of case, and you did not file any. You've been given a free now. You don't have time.
But the rules of the Supreme Court, respectfully, do not require the filing of a similar case in support of an application for injunction or opposition, unless the court orders, and the court has ordered.
Attorney General, yes, you may do what you please.
No,
you may do what you please.
I'm only stating the true position of the law. That it is only in the High Court that similar case is filed, but unless the court orders, which the court has ordered. And
Attorney General, if you do not want to file any statement of case, that is your option. But I will not hear you.
No, but
I'm just informing you. I will not hear you. May I have the last word? Thank you. Good morning. Suit is Agent Sanida. You have another.
Well, we are grateful for your indulgence. The series of amendments proposed by my friend and all. Even though I'm not for him.
Respectfully, my lords, writ number J1/13/2023, Dr. Amanda Odoy versus the Speaker of Parliament, the Attorney General. Are you Dr. Amanda Odoy? What's your name? Please, can you remove the mask and these people? Go ahead. Yes. Andrew, welcome. About representing the plaintiff. The Speaker of Parliament. Lord Edwin Tufuo. Legal officer. Lord, the second defendant, Attorney General, is present.
As a plaintiff of counsel.
May it please the court, Dr. Ernest Akun, with Benedict Nikraku for the plaintiff applicant.
Dr. Ernest Akun, is that A-R-K-O?
Melody A-K-O.
With
Benedict Nikraku, Ni-K-R-A-K-U.
Yes.
If you please the court that you sorry for the first defendant respondent. With me is Raphael Banawin.
lady, if you please, the court, Godfred Yeboah Dame, the Attorney General, appear with Dr. Sylvia Adusu, Chief State Attorney, Mrs. Vivian Opoku Ejakwa Adusu, Chief State Attorney, Mrs. Vivian Opoku Ejakwa, Principal State Attorney, and George Saki, Principal State Attorney, the second defendant.
We have before you a motion for interlocutory injunction. Lady, we have a difficulty.
Difficulty? What's that difficulty?
Lady, on the 22nd of March 2024, the first defendant respondent filed an affidavit in opposition. And then on the 30th of April 2024, he filed a supplementary affidavit in opposition without leave of the court. And lady, a very close look at the supplementary affidavit, apart from being filed without the leave of the court, contains very strong language and statements that are prejudicial to the case of the plaintiff applicants. And Lord, my lady, we feel that we should be given an opportunity to respond. Lord, especially when in paragraphs 12, 14, and 20, there are allegations of collusion, lack of candor, suppression of facts. Lord, these are very strong statements that we think we should be afforded an opportunity to respond to.
You say you want to respond to the affidavit that he has filed without leave.
Yes, my Lord.
He has filed a supplementary affidavit without leave.
Yes, my Lord.
And you want to respond to the contents of that affidavit.
Yes, my Lord.
Dr. Kun, let me understand you better. Do you want to respond to the language, or you want to respond to the content?
Not the language. We are not going to.
So regarding the language, what are your submissions?
Lady,
Since you referred to them.
Lady, our submission is that the language is scandalous and ought not to stand.
So if it's scandalous, ought not to stand, what do you want?
Lady, we want either the court strikes.
You either say something or you don't.
Lady, we're saying that the court should either strike it out or the first defendant does the honorable thing.
Are you going to finish your sentence?
Lady, I'll finish by saying that he does the honorable thing by either withdrawing the supplementary affidavit or taking steps to correct what is not supposed to be in there.
So now you don't want the leave to respond to it.
You see, Doctor, if you have an objection, say so. Tell us what you're objecting to. Tell me what you want me to do. Then I can do it. But it's inappropriate to get up and just make comments and sit down. What do you want from the court?
Lady, what we want from the court is that the supplementary affidavit filed on the 30th of April was done without the leave of the court. That sins against the rules of court.
Which rule?
My Lord, there's a case law.
Which rule?
Then I'll go to a case first.
All right.
But Order 20, Rule 9 of the CR 47.
Hold on. You know we are not in the High Court.
Yes, my lady.
It was filed without leave of court.
Yes, my lady.
And you rely on Orders 20.
The Lord will first cite the case of Nana.
You rely on Order 20.
Lord, we are relying on the case of Nana Kusia Jimai.
Are you abandoning your reference to Order 20?
Lord, my lady,
you cannot start and stop.
Yes, my lady. Lady, I'm sorry, but Order 20 Rule 9 is on the scandalous nature of the affidavit.
And yes, and so?
So that is Order 20 Rule 9.
Let me tell you what I've got here.
Yeah.
We have an application for interlocutory injunction.
Yes.
The first defendant supplementary affidavit of 30th April 2024 was filed without leave. And we rely on
The case of?
You rely on
The case of Nana Kusia Jimai.
Nana
Akusia Ajiman versus Trustees Synagogue Church of All Nations. There is civil motion J8/30/2010.
My lady, it's 2010 Supreme Court of Ghana Law Report. I think I recall that it's page 707 there. I was just trying to. Oh.
I'm assisting my friend. He's a friend.
yes, you rely on that to make which point?
On this case?
Yes, to make which point?
Yes. And so the point we're saying is that he should have come to the leave of the court. He hasn't done so. And the statements in there are prejudicial to the case.
No, you're jumping. Do one thing at a time.
Yes, ma'am.
You said he filed it without leave of court.
Yes.
You rely on this case.
Yes.
To read the
case. The case is to the effect that.
Read the ratio that you are relying on.
My Lord, I don't have the case.
Then how can you cite them?
Lord, I know it.
Can I finish my sentences?
Very well, lady.
If you're not prepared, don't stand up and make a point.
Lady, I'm sorry.
Yes, because you had all of this before you came here. And you stood up to move your application and decided to make a point. So why are you not prepared? If you don't have your authority here, then I'll discard it.
Lord, we have the authority.
Go on. Pardon me?
We have the authority here. Lady, the authority is to the effect that they should have come by a motion of notice, and they have not done so.
They should have come where?
They have come to the court formally to seek leave for filing the supplementary affidavit, which they have not done.
So what do you want me to do?
So we are asking for an opportunity to respond to.
How do you respond to something that is incompetent? That is
Order in court, please. Order. Order in court.
Order in court, please. Order.
Lady, so our first point is that it should be struck out, but if you want to leave it in, then we want an opportunity. Lady, then we are asking that it should be struck out.
Malidi, we are vehemently opposed to the application, and we have just 3 short grounds upon which we are opposed to it. The first ground is that the trustees of the Synagogue Church of All Nations case, on which he relies to make his case, no, he wanted a citation. He didn't have it. So I just gave him the citation. So I'm well versed with it. And my submission and response is that it says nothing close to what he says in this court. There's no issue there about the supplementary affidavit.
You led him into temptation in order to shoot him down?
No, he was not in his own temptation. It says nothing close to that. The case had to do with the manner of raising preliminary objections in this court. And the court considered Rule 5 of the rules of the court and then distinguished between...
Read the relevant.
Oh, just a second. What is it? Not very long ruling, but the first sentence says this. The rule of practice, when declared by a court of competent jurisdiction, must be followed until that court has a higher court has declared it to be obsolete. And I'm going to explain what the court said in this context. That once it comes to preliminary objections, the long-standing practice
from the law report.
There are about 3 holdings.
Read all the holdings.
Oh, very well. When a preliminary objection had been raised to a motion, the grounds of the objection shall be apparent without recourse to the affidavit or supporting documents. If that could not be done, then the preliminary objection would be improper. That rule was, however, subject to the operation of Rule 79 of the Supreme Court, Rule 16, dealing with non-compliance. Thus, whether a breach of a rule of practice should be held to be fatal or result in proceedings being set aside as irregular or waived would depend on the circumstances of the case. Prejudice to the other side being crucial, and that's what I'm going to refer him to in my next point. And where a jurisdictional point was involved, as in the instance case, a breach of the rule of practice or procedure could hardly debar a preliminary objection, notwithstanding that evidence might have to be called by way of affidavit or otherwise. In the instant case, the notice of preliminary objection in the affidavit in opposition went to the jurisdiction of the court to entertain the applicant's motion for stay of execution, and did not matter that it was based on the position as to facts. The respondent's preliminary objection could not, therefore, be said to flag the rule of procedure related to the raising of preliminary objections to motions. Per curiam, the legislative mood of the Supreme Court, 1996, CI 16, towards non-compliance. Should I go?
No.
It has nothing to do with it. So, first of all, yeah. Oh, well, there are a few more, just a second point. I said there were 3. The second point is that my friend gets up to just make sweeping allegations against me that the affidavit contains scandalous material and makes reference to paragraph 12 and a number of them that I can't immediately recall. But it is important if this court would have to agree with him for him to tell me which one he deems scandalous. When I say, looking at the nature of the affidavit filed by the Attorney General, it appears to align with the case you have been making in this court. And so I have even indicated in the supplementary affidavit that at the hearing of this application, I'll be seeking leave of the court to have this supplementary affidavit admitted. And so, insofar as the application is concerned, even if it were proper, he needed to indicate to this court which part was scandalous, so that the court will exercise its discretion to find out whether it is really scandalous or otherwise. My lady, given the deposition that we have made, that is to ensure expeditious trial, disposal of this case. If we had filed a motion for leave, the court would have granted leave, would have, or otherwise, then would have had to come back. So at the hearing, I've indicated that I will be seeking leave of the court. So it aligns with the court's own duty to ensure an expeditious disposal of the application if this matter is brought to the attention of the court at this stage to make the order. And in any event, like the trustee's case that he cited, without getting to the point that you should have gotten to, he has improperly involved. My lady, I'm most grateful.
But just regarding the point of leave to file supplementary affidavit, respectfully, I consider it to be well established in the practice of this court that when an application has been filed or when an opposition has been raised in the form of an affidavit, further filing of an affidavit in the matter has to be with leave of the court. But I think that is well established. I'm really at a loss as to why my dear friend is raising the issue with that practice. Otherwise, a party will have unrestrained liberty to be filing processes in the matter, even after the other side has responded. The Attorney General filed an affidavit in answer to the application on 16th April. And respectfully, if indeed another party can, after the motion has been fully considered for hearing, be filing without leave affidavit in the matter, I think that it doesn't augur well for good practice. That is my response. So I would think that in accordance with well-established practice of the court, a supplementary affidavit has to be with leave of the court. Regarding the matter of whether the content of the affidavit filed by the first defendant is scandalous in some parts, I myself have actually noted some paragraphs in his original affidavit which are scandalous, and I was going to raise it. I've noted it here. This morning I noted it even before I came. And I also find that some of the paragraphs, with all respect, are also argumentative. They argue only points of law, which again offend the rules regarding affidavit or content of an affidavit. But I don't know if the court would like me to proceed to point out the paragraphs in his original affidavit which are scandalous, or I should
no. You are on your feet now because you are responding
the supplementary affidavit.
Yes,
that's right.
You are responding to the submissions
whether there has to be leave
of Mr. Dr. Aku.
Thank you very much.
Not your own submissions.
Yes, my lady.
Ready for you.
It's because the
I'm not ready for
very
you.
well. I just wanted to bury a
No,
point
I'm
of
not ready
procedure.
for you.
Very well. Because when you say well-established practice, you must substantiate it with something. Very well, my lady.
You indicated that you had, it was part of the supplementary affidavit that you would pray the court to admit it. Which paragraph is that in? That's what I was looking for.
Paragraph 21.
21.
Yes, my lady. And this is...
Hold on. I asked for. Mr. Sorry.
Yes, my lady.
You did not say that you would pray the court to admit it.
I didn't use the word prayer. I said the court
You
should
said-
admit it at the hearing.
You said it is important that the first defendant instant supplementary affidavit be admitted. It's important to who?
To the first defendant, because we have filed it. It must be...
So if you want to pray, say so.
Very well. I apologize. But I've given an indication that I will want it admitted at the hearing, and I'll just give that indication. I apologize, my lady. I'm learning some of the legal things that I should use to properly prick the bosom of my lady to apply the law. Prayerfully.
Beg your pardon.
I say prayerfully. Making the application now.
For the admission of your supplementary affidavit.
My lady, yes. It was in accordance with that I wanted to respond to the Attorney General's.
I thought you would end your response with this.
Very well.
Since there was no humility in your response.
Which one is that? This one that I prayed my lady that the court should.
You had to go around before you found your humility.
Because I didn't respond to the letter Attorney General's accusation. That's the reason that I will leave it there.
Mr. Sori? Yes. The court must make clear to you that apart from the fact that it was procedurally wrong for you to file this supplementary affidavit without leave, the court had reservations about much of the language in the affidavits of your deponents, which carry the stamp of your law firm and your name.
So is it
each of these affidavits has your name at the bottom.
Yes, my lady.
For instance, in the supplementary affidavit, this use of the language have deliberately, which paragraph is it? Have deliberately, paragraph 12, have deliberately suppressed the fact that the concerns raised by the letter which they flaunt before the court is intemperate.
And
Hold on, I'm not done at all.
yes, my lady.
Paragraph 14, accordingly, it is plainly lacking in candor. There's just too much of it. When you go to the original affidavit by this second one is by Nestina Broker. The first one by Mary Wendy Yabua.
Yes, ma'am.
That was very difficult to read. You're a very senior lawyer.
Yeah, my lady.
Mr. Tim, you're a very senior lawyer. What is particularly despicable and a definite desecration, you can hear me. Unless you want to do this. But I'm sure, that's why I say you're a very senior lawyer. Mr. Sorry.
Yes, my lady.
Unless you just want to be insulting in affidavits. If that's what if that's what you want to do, you can tell me you will not withdraw it, and then I will give a ruling. But please listen to me.
Very well.
I think that the language is intemperate. A lot of the paragraphs contain language that's inappropriate, scandalous. So I want to give you directions.
Very well. My lady, I'll go with the directions of the courts. The point I wanted to make was that each of these, maybe it was strong language I used given the circumstances, but a reading of the affidavit would reveal the reasons for which I make those statements. And so I'm guided by the courts.
As Attorney General,
so if I say...
as Attorney General has indicated, it's argumentative, you see? So if you have points of fact, state them.
Oh, yes.
But these kind of opinions, these kinds of descriptions, these kinds of references, I think you need to review it.
But my lady, is coming from the court that if we were to go,
I'm not going back to Attorney General.
Because
no, hold on. I'm not going back to that. That's why I've chosen to speak with you.
Very well. So I just want to make a small point, which is that my lady, in the well-established practice of the court, as the Attorney General has pointed out, we would say, advised by counsel and verily believes it to be true. And the point is made there.
Mr. Sor, are you going to be guided by me?
That's what I said.
Then kindly sit down.
Very well.
By quote, the court is of the view that several paragraphs of the affidavits of the first defendant's deponents contain language that is intemperate and inappropriate. First defendant is directed to refile a fresh affidavit, raising all matters of facts that they wish to bring to the attention of the court and any other process that they may deem relevant.
Most grateful, my lady. Yes, my lady. We'll file within 7 days.
No, my lady.
Sergeant Sanda.
But you are grateful.
Lady, respectfully, do we have an opportunity to respond if they file? Yeah. Very. My lady, there is an affidavit in opposition already.
Sitting by him. My lord, if he seeks the help, and ask directed by him. I'm seeking the
Yes, my lady. My lady, the point I'm making is that he has an affidavit in opposition already, and this one is a supplementary one.
Order in court, please. Order in court, please. The panel will be reconstituted. All rise. Please may resume your seats.
by force. So the cameras